Have you ever felt unsatisfied with a public body's decision? For example, your local council or the National Health Service in your country or any other types of organization that delivers a public service? Well, what can you do? It's not like they have a court system like the judiciary where you can just appeal. Who do you ask for help? Now, we will introduce you to a brilliant tool to help you in your situation. It's called the Judicial Review. It connects the Executive Department and the Judiciary Department. But remember, it is only a tool, not magic. Your success depends on your case and the principles laid down by the law, such as the rule of law, the separation of powers, and the parliamentary sovereignty. Good luck now!
Hello everyone in front of your electronic devices who is watching this video presentation. My name is Florence and I'm so grateful to have the chance to present with three of my friends today and here on the topic of judicial review. So the topic that we will cover today is about the three theories under the judicial review, and we want to determine that which of them will be the most suitable theory that can be used here in order to maintain the lawfulness of the society. We all know that the current worldwide event, which is the COVID-19 pandemic, had already brought a lot of issues, problems, and also effects to the individuals, to the communities, and also to the states. So it will be very important for a government to choose the theory that is the most suitable for this situation. Before we go into this topic deeper, we need to know and understand what is a judicial review first. Basically, judicial review is a kind of court proceeding which its function is to examine the action or decision made by a public authority in order to determine whether such actions are following the law tightly and on in high consistency with the Constitution. In a judicial review, the concern will not be emphasized on whether the conclusion reached is right or wrong, but the obligation of the judge in a judicial review is to consider whether the challenged decision is in a lawful manner or not. When we turn back to look at the historical background of judicial review, it was firstly established in the case of Marbury and Madison in the year of 1803, which the fourth Chief Justice of the United States, who is known as John Marshall, had decided this landmark case and provide confirmations about the principle of judicial review. Not only in the United States but also in the United Kingdom, the legitimacy of judicial review is also playing a very crucial role in controlling the exercises of governmental power, which this can be seen in some of the UK cases, such as the Padfield and Minister of Agriculture, Fisheries and Food in the year of 1968. Thus, going back to the topic today, there are three different theories under judicial review, which are the red light theory, green light theory, and also right best theory. And all these theories are being practiced in different periods with different purposes in order to resolve the legal issues in the best way. In order to look at this deeper and clearer, I would like to invite Dina to share with us about the information of the green light theory first. So, welcome Dina.
Thank you, Florence, for the question. Hello, everyone. My name is Dina, and today I will be explaining to all of you about the green light theory. The green light theory is a branch of administrative law where it limits the role of the courts and underplay the existence of general principles. The purpose of this theory is to encourage efficiency in the governing process and policy making. The green light theory tends to focus more on non-judicial remedies and procedures. For example, political processes, internal and external administrative, review, and consultative decision making. The green light theory considers that the function of administrative law is to facilitate the operations of the state. It is based on the rationale that bureaucrats will function most efficiently in the absence of intervention. Administration should aim to help simplify the procedure and enhance efficiency. According to Harlow and Rawlings, it was said that lawyers often see their own function as resolution of disputes and administrative function only from the outside. They stereotyping the external control through adjudication. They believe law operates as an external control, often retrospectively. For example, law is the policeman, it operates as an external control. The main concern of green light writers is to limit the influence of the courts. In their views, courts always come in the way of progress and the control which they exercise as unrepresentative and undemocratic. To highlight this crucial point in green light theory decision making by an elite judiciary imbued with a legalistic, right-based ideology and eccentric vision of the public interest, it was never a plausible counter to authoritarianism. Tompkins, in defense of the political constitution, he stated that the difference between red light theory and green light theory introduced by Harlow and Rawlings are based on four principal differences of view that are on law, on the state, on notions of control, and on liberty. Tompkins goes on and stated that green light theories believe that the law is nothing more than a sophisticated or elitist discourse of politics and neither autonomous from politics nor superior to administration. They hold on to the belief that public administration is a positive attribute to be welcomed by all citizens. Moreover, they believe that the objective of administrative law and regulation is not just the extent of stopping bad administrative practices, but to encourage and facilitate good admin practices in the government. Policymakers hold the belief and duty to control administration by channeling and guiding the government into good administrative practices. Courts are not the best instrument to uphold these objectives. Furthermore, the goal of green light theory is to ensure every individual achieve liberty where liberty is conceived. If the collective liberty is not constituted by the state, at least it is facilitated by the state and definitely not necessarily threatened by the state. An illustration laid down by Tompkins was the state has wished to house the homeless and feed the hungry as well as educate young. The role of administrative law is to help the state perform this task very well. Above all, it should be noted that green light theories are focused on question of law's relationship specifically to public administration.
Thank you, Dina, for sharing with us the useful information about the green light theory. And now we will move on to look at what is red light theory. And I would like to invite Nurin to talk about this with us. So welcome, Nurin.
Hello everyone, I am Nurin Ilyana and today I will be introducing as well as explaining to you what the red light theory of administrative law is. So first off, Carl Harlow and Richard Rawlings first established this traffic light analogy so that we will further appreciate these theories of administrative law. These theories contradict over matters such as the law, liberty, as well as the state. This theory has long existed ever since the 19th century of the Dyena constitutional research. These red light theory advocates are normally doubtful of the executive and concur that the state should be regulated and stopped from standing in the way of the individual's rights, and that the state's power should be modulated by the courts. However, some theorists of the red light theory also believe that politics is less condescending over the law and that the law needs to keep an eye out on the administrative state. Others believe that this theory's purpose is to increase the liberty of an individual whilst having absolute absence of any external restrictions. These views are shown to be more politically traditional and are mostly advocated by people who prefer a much minimalist government. These theories basically states that a less governing government is better. Having more power is equivalent to the endangerment of liberty as well as the rights of an individual. Consequently, this theory therefore carries out the purpose of limiting the court's arbitrary power. To be simply put, a red light theorist is one who believes that the administrative law is setting up a system which controls the operational power of the government. One very well-known red light theorist is A.V. Dicey. According to the red light theory, the administrative law purpose is to regulate activities of the state in order to provide protection to the individuals. In another sense, it says that the administrative law must be formed on grounds of providing safety and security to the individuals. As administrative law guarantees the secureness of individuals, anyone who falls as a victim under any crime or dangerous circumstances, the administrative law will take effect in order to provide judgment as well as penalties. As soon as this is done, the court will be able to determine and come up with the correct judgment along with punishment for the crime according to the correct rules and regulations. This guarantees the protection of an individual. The red light theory also plays a very important role where there are ultra-vires or unilateral judgment involving the rights of both involved parties. This can be seen in the case of M versus Home Office 1993, where the House of Lords held that the defendant acted in accordance with the court and that there was no injunctive relief against the Crown as according to the judicial review. It should be seen that the emphasis of rights should also include both the rights of the individuals and the group, as well as the main focus of this theory is to provide protection to their rights.
Thank you, Nurin, for sharing with us about the very useful information about the red light theory. Now we need to move on to look at what is the right best theory about. So now I would like to invite Syakirah to talk with us what is the right best theory. Welcome, Syakirah.
Thank you, Florence. My name is Syakirah, and I'll be talking about the rights-based approach. So the feature of constitutionalism based on rights can be understood from many perspectives. What I said here will not be the end of the list. Before anything else, it is affirmed that only people can be right bearers, as there are rights protecting the basic necessities of men from those who have public power. This is because the overriding aim of a public law is to protect the citizens' rights. The aim of a court reviewing a public body's decision or act is to pursue justice, particularly in the form of rights. We can look at the importance of this approach by looking at a principle of the state's morality, namely the morality of the ties between the citizen and the government, where the government retains its power as a trustee of
the citizens. So, although duties are primarily a moral construct, rights are essentially a legal construct. In short, the ruler must maintain and exercise its power for the sake of the people, and failing to do this equals tyranny. To apply this approach, certain contemporary reports suggest that unreasonableness can be a violation of rights, which means a public body's decision is unreasonable if it disregards the rights of the complainant without reason. While according to Sir John Laws, in the cases of judicial review, the more power possessed by a public body over the citizens' rights, the greater the justification that has to be demonstrated by the public body. When speaking about the rights-based approach, we can say that the Human Rights Act 1998 has affected the judicial review significantly. In the case of ex parte Naseri, the House of Lords clarified the correct judicial approach for requests of judicial review based on the claimed violation of human rights. Lord Hoffman claimed that when judges are considering an appeal for judicial review, the focal point here is if they made the decision on the authority of the law, which means their concern lies with the procedure of the decision instead of the quality of the decision. However, when an appeal involves a breach of a convention right, the judge's method must vary. The focus is on whether there is a violation of the applicant's convention right or not. In another word, law explaining rights is a higher order of law which even a legislature is subjected to. The courts are assigned the duty for executing this higher law against countervailing governmental action. This also highlights the fact that the security of fundamental rights in compliance with the concrete conception of the rule of law is an important feature of a government.
Thank you, Syakirah, for providing us the very useful information about the right-based theory. So, among the three different theories under judicial review, all three will be supporting the fundamental rights from different kinds of perspective and for different types of situations. And now we need to consider which of them will be the most suitable theory that can be applied in the current situation. So firstly, I would like to ask Nurin on your opinion. So do you think that the red light theory can be applied in this situation?
No, the red light theory could not be applied here because it provides excessive attention towards the control of the state's power. Harlow and Rawlings proceed to state that it is not shocking to find many writers who claim that the precedent role of administrative law is to carry out regulation on the excessive state's power as well as the legal and judicial control.
Thank you, Nurin, for sharing your answer for this question. So now we need to consider whether the right-based theory can be applied in this situation or not. So I would like to ask Syakirah on your opinion on, do you think that this right-based theory can be applied here or not?
In my opinion, at this moment, in this situation of COVID-19, if moral values are seen as duty and not rights, the subservience of the state to the people will at length become corrupted, where the state will see itself as only the provider of sustenance and entertainment to appease public discontent. From that, it may begin to contemplate policies and laws tailored to placate and satisfy the selfish desires of its greedy citizens, whom in the end it will come to despise. That is no doubt the worst case, and we would not want this to be the cause of an Armageddon. Thank you.
Thank you, Syakirah, for sharing with us your opinion on this question. So it seems like both of the red light theory and also the right mass theory will not be that suitable to be applied here. So Dina, what's your opinion, and do you think that green light theory is the most suitable theory that can be applied in this current situation?
In my opinion, green light theory would be the most suitable theory that is applicable to the current situation right now, that is the COVID-19 pandemic. This is because the green light theory would create the state power in a more positive way. A good state power is considered as a crucial element that will be effective for social policies, and at the same time, it will not only bring advantages to the general public but also to the specifically defined communities.
So we can conclude that the green light theory will become the most suitable theory that can be applied in nowadays situations of the COVID-19 pandemic. So at the end of the day, based on the statement given by Matthias Clark in his journal article, it could not be denied that since we are now living in a real and imperfect world, judicial review will be playing a very important role in solving all kinds of unfairness, illegality, and irrationality in order to ensure that the rights of the people are always being protected. So that's all for our video presentation today. We would like to thank you for watching this video, and goodbye.